The starting point for me is to underscore the fact that the local government system in Nigeria, in terms of the practice that is prevalent, is a travesty in most of the local governments. And I think that point has been made very clear. The other point clearly is that, as we say in law, res ipsa loquitur. It is self-evident. The thing speaks for itself in terms of the very parlous state of our local governments. But with particular reference to the question you have asked regarding autonomy in concrete terms, I'd like to bring to bear my experience when I had the privilege of serving as the lead consultant to the House of Representatives Special Committee on Constitutional Review, especially under the 9th Assembly. There were two fundamental issues of autonomy that were addressed. The first is the financial autonomy of local governments. The second is the administrative autonomy of these local governments. Now, let me conceptualize this and give you a sense of what transpired. In terms of the financial autonomy of local governments, the challenge essentially has to do with Section 162 of the Nigerian Constitution that makes provision for a state joint local government account. And so you find that in many states, they use the instrumentality of that provision to undermine the financial autonomy of local governments. Now, what the 9th National Assembly did in the context of constitutional amendment was to now provide that the funds that are due to local governments should go directly to the local governments. In terms of administrative autonomy, the amendment that was made sought to go beyond the very blanket provisions of Section 7 of the Nigerian Constitution. And it now addressed the challenge of caretaker committees, the arbitrary and unlawful dissolution of local government councils. And what it provided for was to reinforce the fact that local government councils must be democratic, and that where a particular state unlawfully dissolves a local government council or puts in place a caretaker committee, that such local government should no longer have the benefit of any funds coming from the federation account. These were the two fundamental issues of autonomy that were addressed in the context of the constitutional amendment. Unfortunately, and I'd like to give you statistics, in respect of financial autonomy, and keep in mind that the process of constitutional amendment requires that the bill is passed by both chambers of the National Assembly. It is transmitted to the states, and you need 2/3, which is 24 of the 36 states. In respect of local government financial autonomy, only 16 states voted in favor. 11 states voted against. 3 states abstained or did not clearly indicate what their preference was. And 6 states did not transmit any returns to the National Assembly. In respect of local government administrative autonomy, only 15 states voted in favor, 12 states voted against, 3 states abstained, 6 states did not make any returns to the National Assembly. So this is to give you a sense of the fundamental challenges that we face. And I hope that in the context of this engagement, we'll have the opportunity to go beyond the lamentations and focus on what needs to be done in the context of the current constitutional amendment in order to address the challenges that bedeviled the last exercise.
To kickstart that contribution in terms of what needs to be done, what are we not doing right at the moment that we need to now do to make progress? I said, what is it that we are doing now that we need to stop? What do we need to do to make progress in, enhancing the autonomy of local governments?
There was a recent national discourse on local government autonomy, and I had the privilege of being the keynote speaker, and I put forward a number of proposals about how to address this challenge. The first is that in the context of constitutional amendment, we need to take a look at the process of constitutional amendment itself. The current procedure is set out in Section 9 of the Constitution, and which is the section that says a bill is passed by the National Assembly, it is transmitted to the states, and you need 2/3 of the states, which is 24. And the first proposal that I put forward is that you need to go beyond what Section 9 provides. That you need to, first of all, amend Section 9 of the Constitution so that you now provide for a referendum. In a number of countries, including the United States, there are ballot initiatives. Since it is becoming increasingly difficult to get the states to come on board, you now need to amend Section 9 so that local government autonomy, for instance, can become a ballot initiative. And you can then subject this to referendum at the next general elections. Let us take this matter directly to Nigerians beyond what is happening at the level of state houses of assembly. The second proposal that I have put forward is that you can do a give and take from what transpired in the last constitutional amendment exercise. Most states, as I pointed out, given the statistics that I reeled out, were against local government autonomy. But on the other hand, you found that the National Assembly passed the requisite bills in respect of local government autonomy. Now, so the National Assembly is for local government autonomy. The majority of state assemblies so far are not in favor. But look at the flip side. The National Assembly is against state policing, the devolution of state policing powers to the concurrent legislative list. But on the other hand, the majority of states, so far there is momentum at the level of the states for state policing. So why don't we have a give and take? And I propose that what the National Assembly needs to do is to put in place what I call a strategic coupling of the bills. Let us have the bills on local government autonomy and the bill on state policing together. That way, states that are for state policing will invariably have no choice but to vote for that bill because they stand to benefit from the local government, from the state policing component. The National Assembly that is for local government autonomy can then pass the bill, and that way you find that, hate or tell, it is possible for local government autonomy bill to be passed because the National Assembly has something to benefit from it and the state assemblies have something to benefit from it. There are a number of other proposals that, if given the time, I will put forward in order to address this challenge that has been very recurrent.